Josh Whitaker. This is Joe Hamer. We're attorneys with the law firm of McCullers, Whitaker, and Hamer. Welcome to Real Estate Closings 101. Today's topic is power of attorneys for sellers. So today we're going to take a quick look at a seller who needs to use a power of attorney to sign documents at a real estate transaction. And so the first most important thing I would point out is that that's okay. A seller can do that. Usually, the one thing we're going to ask is that we know ahead of time. So as soon as the file gets set up with us and we contact your agent, they need to let us know our seller needs to tell their agent that they're going to use a POA. And then we need to know because we need that POA. So hopefully that POA is already recorded down at the Register of Deeds for the county where the property is located, because that's what we want to see. So if you're a seller and you've got a recorded POA for someone that you're going to use to sign, it's recorded. We just need to review it. We need to know it exists. We need to make sure that POA allows you to sign on behalf of someone else. And so we'll usually review it. If it's good, we just need to make sure it's on record in the county where the property is located. And that's the big thing. And that doesn't sound very hard, but you would be amazed at how many times we're in a file and we find out at the last minute someone's signing with a POA. That POA is recorded in Pennsylvania. We've never seen it. And obviously a lot of delays can ensue. So as long as we know ahead of time, it's very rare, I would say, Joe, it's very rare that I see a POA that someone plans to use where we don't think it's effective.
I agree, especially in the situation of a seller using it. And if you don't have a POA and you decide you want your seller to be able to sign by POA, a lot of times what we're going to tell you is that's a bad idea, because in order to execute a POA for closing, you're going to have it signed, you're going to have it notarized, which is the exact same process you're going to have to do to sign the seller documents themselves.
Yeah, I would say so. Sellers never have to be at closing. Sellers really can sign everything ahead of time, and I would recommend that they do. There's no reason for them to schedule to be there on the day of the closing. Let's get your side done, and you're ready to go. And that's true. So if you don't have a POA, but you decide that someone wants to sign with a POA, it doesn't make a lot of sense to us, because you're just going to have to get something notarized anyway. So either way, you're going to go sit down in front of a notary, and we need the originals back. So a POA after the fact doesn't make a whole lot of sense.
It doesn't really help you. You just sign. We're going to tell you to sign the documents you would sign anyways in advance, so we don't have to charge you for a POA, for recording a POA, and then still charge you for the documents, because we're going to have to prepare them anyways. If for some reason you insist on doing that, and that is the way you want to go, it's just very important to know that either let us prepare it so we know it's legally sufficient, or if you have another attorney prepare it, make sure that we review it. And then you're going to have to provide the original, because again, we're going to have to record it. We can't operate off of a copy, so you're going to have to get that original over to us. Now, there is a distinction between POAs to sign your deed, your lien waiver, and all the legal documents for recording, and then a POA for just having your real estate agent sign either the closing disclosure or the HUD at closing. Now, in North Carolina, arguably, you don't have to have a POA for that, because agents can sign for their clients. But a lot of times we see picky lenders who are going to want to see a seller POA to their agent in the event that that agent is signing for that client. So in that case, we generally are going to prepare that for you. And that's a little bit more common. And it's a little bit more of a specific form and format that we can kind of spit out for you very easily. So a lot of times, if you let us know that you're going to attend closing and sign for your clients, we're going to go ahead and prepare that POA in advance, just out of an abundance of caution. So, but there is a distinction between that and between a POA that's actually going to allow either a spouse or another third party to sign the deed, the lien waiver, those documents on behalf of their client.
So real quick, just a quick recap. If you have a general power of attorney and that's what you're going to use to sign, we need to know it exists. We need to see it. And if the original is not recorded in the county where the real property is located, we need that done, preferably as early as possible, just in case there's a problem. We can let you know. And of course, that's different than a limited specific power of attorney that we will prepare if you're not coming to closing for your agent, so they can sign things that come up the day of closing. So two different things. That's all I've got, Joe. All right. Hope that was helpful. See you next time.